Hello, everyone. This is Bruce Van Bredy. I'm Director of Marketing for Bradyware CPAs and Advisors. I'm here again with Mark Hassens, who leads our estates, trusts, and gifts division of Bradyware. We're doing several of these videos, and this one is going to cover, or at least kick off anyway, our series on trusts. So this one is going to cover grantor and AB trusts. Mark, before we get into that, why don't you start us off with why does somebody want to consider a trust to begin with?
Yeah, sure. Number one, it's control. Whether it's during their lifetime or from the grave, it's control over their assets, what happens to their assets after their death, and who gets those, whether it's held in trust, whether it's distributed outright to the beneficiaries. It's really about control. Secondly, it avoids probate, and probate can be an expensive, cumbersome process. It's where the courts are involved. So the court is supervising the administration of an estate without a trust. If you have a trust, then the estate can be administered, free of that. And it's just up to the trustee, really up to the trust document. The trustee is to follow the instructions left to them by the settlor of the trust, the person who sets up the trust. So it can be used for a wide variety of reasons, whether it's protecting the beneficiaries, sometimes from themselves, to kind of protect those assets, but yet provide an income stream for beneficiaries that might not be ready to inherit a large chunk of wealth at any given time. And sometimes those are made to hold life insurance. So we have life insurance trusts, irrevocable life insurance trust, or ILITs. We have charitable remainder trust or charitable lead trust that involve setting assets aside for income source, or the income either goes to a charity during your lifetime, or in a remainder trust, the income comes to the settlor of the trust. And then at the end, the charity gets the assets, like at the end of the term or when the settlor passes away. We also have spousal lifetime access trust, beneficiary deemed owned trust, all kinds of different vehicles that can accomplish the estate planning goals of the settlor.
Well, I think in all these videos, just for the listeners and the viewers, we're going to cover all of those. In this one, we're going to cover grantor and AB trust. So start us off with the grantor trust. What are we talking about here?
Yeah, so first of all, grantor trust predominantly are revocable trust, and they're living trust. I mean, when people say, "Oh, I have a trust," that's usually what they're talking about. They have the ability to change it during their lifetime. It's revocable, so it can be revoked or not. So you can go in and change it. You can have amendments to the trust. But in the last several years, last decade or so, we've had grantor trusts come about and are evolved from tax law. People have found ways to kind of create those things to accomplish other goals. So if we have a business succession issue, where there's a lot of value in a small, closely held business, or not small, closely held business for that matter, we can set up a grantor trust that's referred to as an intentionally defective grantor trust. And it's not really defective. I mean, it really is planned out and administered the way it's supposed to. It's not defective at all. It's just kind of the term for it, but it's treated as a grantor trust. So it's taxed as if the individual, the settlor, the grantor, owns those assets individually, and the income just flows directly to their 1040. So you don't have really a separate tax entity. Grantor trusts are disregarded for tax purposes. We also have spousal lifetime access trust, and those again are treated just like grantor trusts. So assets are in a separate entity, but the income is the trust is disregarded for tax purposes, and the income is reported directly on 1040s. So the revocable grantor trust, like I already said, that's really where the settlor lays out their plan for their estate. Um, they have if they have a spouse, they'll set up the various trusts for to care for their spouse for the lifetime. They might have special needs and a child or beneficiaries that they want to plan for. That's all done in the trust while they're alive. And again, those can be changed or revoked.
Okay. So then that takes us to the AB trust. Walk us through that, please.
Yeah, and that's usually part of that living trust of the revocable trust, especially only, well, really, yeah, you have an AB trust when they're married. So the surviving spouse, you want to care for your surviving spouse. Nothing really changes as far as income goes for them. So in an AB trust, that upon your death, section of your trust is set aside into a credit shelter trust. So right now, your credit shelter, we spoke of this in the last video. Your credit is your lifetime exemption. Basically, it's a credit, it's a tax credit equal to the tax on that lifetime exemption. So this is an amount of, let's say right now, $12.92 million can be set aside in that first trust, in that credit shelter trust. And then that escapes, it's basically taxed right then. Well, it uses all of your credit, so your tax is zero. So that first to die, you have a $12.9 million estate. And then the rest of that $12.9 million estate gets a marital deduction. I'm sorry, the excess over that $12.92 million gets a marital deduction, which is unlimited. You can give your spouse as much as you want during your lifetime or after death, and it's not taxed at that time. So let's say you have a $20 million estate, $12.92 million is set aside in the credit shelter trust, and the excess up to that $20 million is put into a marital trust or the B trust. So the marital trust is basically controlled by the surviving spouse. They have rights to withdraw principal, to kind of deplete it if they want to, but they're also getting that income from the credit shelter trust. They can't really touch the assets. They have a little limited or to withdraw some assets in cases of health, education, maintenance, or support, or a 5 and 5 power, less than 5% of the assets. So there are withdrawal rights, but not like there are with the marital trust. So the marital trust gets the marital deduction. Then when they pass away, all that is in their estate. It's taxed, but the credit shelter trust has already escaped that. It's been sheltered from that second to die. So really, you can transfer, almost $25 million in trust assets or in assets at the second death, because you've sheltered that first one, and then the second to die is really where the tax part of that comes into play. So it can sometimes you have to equalize values of estates if they die close together. But in general, that first to die is going to be a tax-free estate, and then everything else goes to the spouse. And then we have to plan for that second to die.
Okay. With trusts, I heard you already mentioned the other word, trustees. So that seems to be a pretty important decision. Uh, what do you encounter there?
Yeah, so it really is something to not be taken on lightly or to be considered lightly. First of all, you're as trustee of your living trust, unless you don't trust yourself, and then you put somebody else in charge of your life. But you're the trustee of your living trust, and normally you make your spouse the successor trustee, or a child that you trust to take care of, basically their mom or dad, the second to die. Um, or, in some cases, people don't really have that anybody that they really think is one capable of having that responsibility, or they don't want to put them in the position of making some difficult choices uh, that could really cause some family strife. So they might have an independent trustee, and there are corporate trustees everywhere. A lot of banks have trust departments, and they are well versed in their responsibilities. One, their fiduciary responsibility. So they really have a professional obligation to serve as the trustee and follow that trust document. And they're also not they're not tied to any side of the family for the most part, and they'll be objective if there's family dynamics that they or personality differences that they have to kind of work around. They can do that in an objective manner. So choosing a trustee it's really important for that next step for after death of that first spouse. Like I said, you know it's you, and then it's usually your surviving spouse. And if they need help, then it's either a child or a trusted family member. But then and also a corporate trustee would be beneficial.
Okay. I also heard you talk about irrevocable and revocable. Could you explain differences there?
Yeah, so on this, like in the living trust, those are revocable. Those can be changed at any time during the settler's life. When that settler passes away, their trust cannot be changed anymore. That the instructions in that trust and everything laid out in that trust, it's set. It is irrevocable when they pass away. So the surviving spouse might have their own trust, and that's fine. That one would remain revocable for their lifetime. But the moment that person passes away, they are the only ones that have the power to change it. Then it becomes irrevocable. Now the other trust that I mentioned before, the SLAT, the spousal lifetime access trust and charitable trust and beneficiary deemed owned trust and things like that. Those are irrevocable when you set them up. So those really have to be thought through clearly, because once you sign the documents and fund those trusts, they're done. And then the trust rules the day, whether you have a change of heart or not. If those trusts have already been set up and funded, um, that's it. I mean, they're done. They cannot be changed. So the important thing about those irrevocable trusts, and why would you do that? Why would you ever want to give up that control over those assets? Um, and the irrevocable trust, like a spousal lifetime access trust, or even an intentionally defective grantor trust, or a beneficiary deemed owned trust, you're really stopping the appreciation from being included in your estate. So if you're already over that lifetime exemption, or close to it, let's just say you're close to it, and let's say you have $10 million worth of assets, and you put them into a spousal lifetime access trust, all of them, for your lifetime, that that's gone. I mean, that $10 million is there that you just funded. But that appreciation that takes place over the next several years, hopefully, before you pass away, that appreciation escapes estate tax. So you could be talking about saving an incredible amount of money just by setting up an irrevocable trust. So that's why people do it. It's to kind of cap that exposure of your estate, the taxable estate, by the value, the current value. All that appreciation kind of skips over that and escapes the estate tax.
So covering these two and covering more in our upcoming sessions. I think you mentioned the spousal lifetime access trust. I think that's going to be our next video. But there's just a ton of content here. There's a ton of information to know. So, I mean, it sounds like starting with someone like yourself is probably a good idea to create that plan and to start working through all the variables that someone is going to have to face.
That's right. Yeah, we can make a lot of impact, a lot of tax savings, but just by planning and being aware of the different rules, being aware of the different options, and taking advantage of what's out there already. We're not skirting the law. We're not creating some sham trust or anything like that. These are well established trusts that kind of everybody's doing it kind of thing, and they're really an incredible vehicle and a really neat way to save tax and to keep that legacy intact, and to let it go through kind of the settlor's wishes, and to not fund the U.S. Treasury, but to create a dynasty for a generation or two to come.
All right. Well, thank you, Mark. Thanks for covering these first two, and we look forward to talking to you again as we work through the number of trusts that are available.